Good afternoon, everyone, and welcome to this webinar on the decision of the Court of Appeal just before Christmas in the case of Bath Rugby and Greenwood and others. Our speakers today are Martin Hutchings QC and Harriet Holmes, and they acted for Bath Recreation Limited, the freehold owner of the site in question, who didn't appear at first instance, but who intervened successfully in the appeal. Martin, I'm sure, will be very well known to a lot of you as one of the leading silks at the property bar and a previous winner of Chambers and Partners Real Estate Silk of the Year. His practice covers the whole gamut of property disputes. And in the area that we're talking about today, restrictive covenants, there is surely no one more experienced or knowledgeable at the bar. In this topic alone, he has been in 3 of the most recent leading cases. Today's case, the leading modern case on building schemes in the Court of Appeal, Birdlip, and last year's 2020's Supreme Court decision in the case of Alexander Devine. Harriet, meanwhile, is very much a rising star of the property bar. She was nominated for Real Estate Junior of the Year last year and manages the distinction of being recognised in the directories, not only for the typical swotty junior fodder of being hard-working and having a good focus on detail, but also for the rather more silk-like qualities of giving innovative and pragmatic advice, whatever that is. The Bath Rugby case marked her second Court of Appeal victory in 2021, following the Mines and Minerals case of Wyn Finch and Natural Resources for Wales earlier in the year. In this session, Martin and Harriet are going to talk us through the case, what it decided, and what the implications for those of us practicing in this field are. There are 2 things I should say at the outset. The first is we are very keen that this session should be as interactive as possible, and we welcome contributions and questions from as many people as possible. So far as the manner in which those questions come in, you'll see in the bottom right-hand corner of the ribbon on your screen a Q&A function, and can I ask you to use that? And then I'll put your questions to the panelists at an appropriate moment, whether that's during the discussion or at the end, depending on where works. The second thing I should say is that, as with most restrictive covenant cases, what crystallised dispute was a development proposal. And as so often, that development proposal is controversial among local residents, and I know that some of them have joined us today. So I should just say at the beginning that this session is going to be about the legal implications of the case and the legal reasoning of the Court of Appeal. We're not going to be discussing in this session the wider desirability of the development that underlies that case. And indeed, it's not an issue on which we as property lawyers would have the expertise to expertly opine. So without further ado, let's move on to the seminar itself. And I suppose the first question, Martin and Harriet, is what was the case about?
So that one's, I think, for me, James. So the question for the court, both at first instance and in the Court of Appeal, is whether a covenant over the recreation ground, an open space in an area in Bath known as Bathwick, and that covenant was entered into in a conveyance in 1922. And the question was whether that covenant is enforceable. I just got some slides up here to kind of quickly trot you through some of the facts. I'm hoping they can be seen, as I'm not necessarily so expert at showing my screen. But the 1922 conveyance that I referred to the beginning of it is found here on the first screen. The parties to it were Francis William Forrester, otherwise known as Captain Forrester, who was tenant for life of the Bathwick estate, more about that later. And the purchaser was the Bath and County Recreation Ground Company Limited, essentially the appellant's predecessor in title. So the first appellant, just so that everyone knows who we're talking about when we talk about Bath Rugby, Bath Recreation, etc. The first appellant, Bath Rugby Limited, is the tenant of part of the recreation ground under a long lease of part of that ground. The second appellant, who Martin and I acted for, is the registered freehold proprietor of the whole of the recreation ground. And so, as we've seen, we've got the vendor and the purchasers described here. you'll note, some of you that are eagle-eyed, that the trustees of the strict settlement were also parties to this particular conveyance. Moving on then, because we were being asked about enforceability, I'm just going to lay out, firstly, the parties to, having set out the parties to the covenant, I'm just going to make sure everyone knows what land is being conveyed, and then go on to sort of explain a bit about the circumstances in which the conveyance was entered into. So the conveyed land, as we've got here on the screen, the parcels clause, it was, as I said, the recreation ground in Bath. That's a large open space in an area known as Bathwick, which is just the other side of the River Avon from the historic centre of the city of Bath. And Bathwick was formerly part of the Bathwick estate. Now, the judgment, and both at first instance and also the Court of Appeal's judgment, sets out some of the history of the Bathwick estate, but suffice to say, for present purposes, that the Bathwick estate, the estate that became known as the Bathwick estate, was essentially once a kind of country village called Bathwick, which was developed mainly by the Pulteney family. Hence, for those of you who know Bath, there's the Great Pulteney Street, which is in this area. And that estate later passed to another branch of the family, known as, well, into the hands of the Earl of Darlington, who later became the first Duke of Cleveland. Now, this conveyance came about because the fourth Duke of Cleveland died without issue. He was possessed of large estates across the country, including the Bathwick estate, which was ultimately settled on our Francis William Forrester, Captain Forrester character, who's the vendor in our tale. Now, the captain had attempted to sell off the Bathwick estate, including the recreation ground, as a single lot by auction in 1919, some 3 years prior to the conveyance we're concerned with. But that the estate had failed to sell at auction. So Captain Forrester tried again in 1921, selling what was described as the first portion of the estate as separate plots, but the recreation ground was not part of that sale, hence we end up with the 1922 conveyance. Now, just to trot through then, make a couple of points clear. So we've got the parcels provision here, all that peaceful parcel of ground situate in the city of Bath, containing an area of 16 acres, 2 roots and 11 perches or thereabouts, known as the Bath and County Recreation Ground. But perhaps somewhat unusually, this conveyance didn't have a conveyance plan attached either to the conveyance or referred to in it. And you'll see reference to that in the judgment. But a contemporaneous plan did exist. It's signed by Mr. Forrester, as you can see, the signature F.W. Forrester up in the top left-hand corner of the plan. And you'll see there that it said that the plan was intended to be of the land conveyed in an indenture dated the 6th day of April 1922. So that's the conveyance we're looking at here. Now, that plan, it looks blue here, but essentially the conveyed land is the pink area and what looks blue looks actually meant to be green. And the recreation ground, the rec as it's referred to now, is the pink land. Now, what you'll see or may note from this plan is that we have Pulteney Street and Laura Place up at the kind of top end of the recreation ground, and there's some sort of black hatching. Now, you may note that neighbouring properties as sort of individual plots have not been identified per se on this plan, but the respondents, the 7th and 8th respondents who were actively opposed, and are the reasons why this was a contested matter, to the application for a declaration that the covenant is not enforceable, the property is roughly within the black hatched area, sort of near the junction between Laura Place and Pulteney Street on the kind of southern side of Laura Place. Just to quickly walk you through then the other parts of the covenant so that we know what language we're referring to when we come to talk about the substance of the decision later. Looking first then at the reddendum, which was contained in the first clause. This, as you'll be able to see, those of you reading the words as I speak, that there is a reservation here of an easement of drainage. And the words to pick up on, because they become relevant in the reasoning that we'll explore, is that when you get to the third line, the reservation was for the free and uninterrupted passage. And then on the third line, you have from the other buildings and land of the vendor and his tenants adjoining or near to said hereditaments. So said hereditaments being the conveyed land. And here we have the reservation of the free and uninterrupted passage, etc., from the other buildings and land of the vendor and his tenants. So firstly, note that it's reserved to the vendor and his successors in title. Secondly, the easement is apparently reserved for the other buildings and land of the vendor and his tenants adjoining or near to the conveyed land. Now, let's get to the covenant itself. And here we do reach the covenant itself. And the point to note here is that we have first, the opening words are the purchasers for themselves, their successors, and assigns here by covenant. So we can see that it's the purchasers in the usual way giving the covenant. And the covenant is made with the vendor, his successors in title, and assigns. And then the next point to note is what follows. So we've got our covenantor, we've got our covenantee, and then the words, and so that this covenant shall run with and be binding on such portions of the hereditament and premises hereby conveyed, as are respectfully affected thereby, is indicating the burdened land. And then we move swiftly on. You'll see where I have the ... I've actually added the emphasis here to break it down. We move on to the restrictions that start with that, no workshops, warehouses, factories, etc. So other than the conveyed land, what we can see by looking at both the covenant, the clause 2, which is the covenant itself, and looking back at the easement in the reddendum, is that other than the conveyed land, the conveyance referred to land other than the conveyed land in only 3 ways. The first area of land referred to other than the conveyed land is in the reservation of the drainage easement, where you've got the other buildings and land of the vendor and his tenants adjoining or near to the said hereditaments. The second area of land referred to in the covenants conveyance other than the conveyed land is in the restrictions themselves, where it says the adjoining premises or the neighbourhood. So that's the third line, where you've got that no workshops, warehouses, factories, etc., to affect the adjoining premises or the neighbourhood shall at any time hereafter be erected. And then we have the third, which I haven't shown you, but you can take it from me, that the third area of land other than the conveyed land referred to in this conveyance was contained in a recital to the conveyance itself, recording the fact of the settlement I referred to earlier on the vendor, in which it was said the Bath Rugby estate in the county of Somerset, on which the hereditaments hereinafter form part, were assured. So there was a recital which essentially recorded the fact that there had been a strict settlement which had been settled on the vendor. So the important takeaway here from when we really are 2 things. So first, the case is about whether the covenant is enforceable. And the second, as we'll see, which became important in this case, is that we had only 3 areas of land other than the conveyed land which are referred to, which are the 3 that I've just outlined. And so essentially the question for the court, it became whether the benefit of the covenant could had in fact been annexed to any land at all. So James, I hope that's given you a bit of an introduction.
It has, thank you, Harriet. And as you said, we're into the territory of annexation. But I think one thing I did notice reading the judgment was that even Lord Justice Nugent reckons that annexation is difficult, and if he thinks it's difficult, it must be. So I wonder whether, before we get on to some of the technicalities of the reasoning, it might help if Martin gave us a bit of an introduction to the role that annexation plays generally in the law of restrictive covenants.
Yes, well, bearing in mind it is a pretty complicated and difficult and sometimes contradictory area of law, I'm going to be fairly brief in what I say and give you a sort of thumbnail sketch. This, of course, is about the passing of the benefit and the burden of restrictive covenants. And as is so often in cases where annexation is in issue, the key question, as Harriet said, is about the passing of the benefit. Very often, when we're looking at the passing of the burden, as it were, whether the land conveyed away is burdened, we can often very clearly establish that it is by reference to the four tests that have been evolved by the court since the great case of Tolkien-Moxhay, which allows the enforcement of covenants in equity, negative covenants in equity. Those four tests for establishing the burden, whether the burden applies: is the covenant restrictive in nature? Is it for the protection of retained land of the covenantee? Is it intended to bind land of the covenantee? And is notice of the covenant available to the covenantor and successors in title? So what we're looking at, however, is the question of the passing of the benefit of a restrictive covenant. And of course, we know that there are three methods by which the benefit may be passed. First of all, by assignment. If you can show a chain of assignments, very unusual circumstances often. If you can show a chain of assignments, that is one way in which you might have enforced as a successor in title of benefited land. Secondly, where there is a building scheme, a scheme of mutual covenants, again, often relied upon, but often rarely established. And the third and main way, perhaps, in which one can establish that the benefit of a covenant is attached to land is by annexation. Now, in this case, we were dealing in effect with express annexation, and we know that whether annexation is applies is a question of the intention being shown by the words of the conveyance, and that requires usually that the land benefited must be indicated in the conveyance, and that the conveyance states that the covenant is made for the benefit of that land, or stated to be made with the covenantee in his capacity as owner of certain land. That's express annexation. Now, it's true that there is also implied annexation, which gets a little bit of a look in our case of Bath Rugby. So where there are no express words of annexation in the conveyance, you can rely on implied annexation, but in essence, it must be clear from the conveyance itself, when construed within the surrounding circumstances, that implied annexation was intended. It is not sufficient for the implication to arise merely from surrounding circumstances. So that is a sort of thumbnail sketch of express annexation. And let me just finally say this, that we are dealing with a pre-1925 covenant. And of course, post-1925, it's often much easier to show express annexation because of Section 78 of the Law of Property Act. You rarely need now to argue for example, implied annexation. Now, this covenant did, of course, this conveyance predated 1925, but to make it clear, the decision is certainly highly relevant both to pre and post 1925 covenants. even though, of course, the respondents to the appeal couldn't rely on Section 78, which of course attaches automatically the benefit of a covenant to land of the covenantee that is intended to be benefited in the words of Section 78. So that's just a very brief sort of sketch of the principle of annexation.
Well, thank you, Martin. Well, Harriet, I wonder if you could explain to us how the judge at first instance dealt with these questions on the facts as you outlined them for us.
Yeah, so basically, as Martin's just explained, by the beginning of the last century, we had sort of two propositions. The first is that the question whether the benefit of a restrictive covenant by B to A is annexed to A's land is one of intention to be determined on the construction of the particular document concerned. And secondly, that there must be something in the document to define which land the covenant was intended to benefit. Now, the respondents had, as we've already seen, relied in first instance on the second method for passing the benefit, annexation, which Martin's just explained. Now, on annexation, there was no dispute between the parties that the burden had passed. That had been quite clearly established. So the main issue, I won't spend any time on burden. The main issue is then whether the benefit had passed the respondents by annexation, as we've seen. And basically, the judge concluded at first instance that the covenant in this case was enforceable, because although the covenant itself did not identify the land to be benefited, the benefited land could be identified by reference to land referred to in the easement of drainage.
So a covenant was construed by reference to a separate easement within the same conveyance. I'm afraid, Harry, you're going to have to explain to me a bit more how the judge reached the conclusion.
Yes. Well, we would of course say that, well, you're right to raise your eyebrows, James, as to how the judge got there. Now, what the judge at first instance said is, firstly, he accepted that there needed to be, as a matter of construction, an intention to benefit particular land. So far he seemed to be playing by the rule book. The second point is that he accepted that the particular land intended to be benefited needed to be identified. So again, he appears to be following the rules. The third point he made was that he rejected a submission that, in addition to satisfying those two aspects, it was necessary for the benefited land to be easily ascertainable. We'll come back to that later. And so he eventually sort of reached the conclusion of saying, well, even though the covenant itself doesn't identify the land is sufficiently identified in the deed, even if not in the covenant itself. And what became the key part of his reasoning, and is quoted twice in the judgment of the Court of Appeal, is probably worth just reading through. He said this: the covenant is one not to do certain things to the prejudice of the adjoining land or the neighbourhood. Now, at this juncture, I'm going to attempt to share my screen again, just because it's probably worth everyone having the covenant in front of them as we look at this. Let's see. That's hopefully sharing it with you. I'm sure James will tell me if I've failed. Is that all right, James? Can you see it?
I can see it on my screen.
Brilliant, okay. So he said the covenant is one not to do certain things to the prejudice of, quotes, the adjoining land or the neighbourhood. Now I'll let Eagle Eye among you decide whether those words are actually in the covenant. He said, in substance, that means that the covenant is for the benefit of the land so described. Adjoining land is clear enough. Neighbourhood means the area nearby. Reading clause 2, the covenant, together with clause 1, the easement of drainage, I'm in no doubt that the phrase the adjoining land or the neighbourhood in both places where it appears in clause 2 is a reference back to the phrase the other buildings and land of the vendor and his tenants adjoining or near to the said hereditaments hereinbefore described. So in essence, where the language that we actually have in clause 2 is the adjoining premises or the neighbourhood. But he read that as adjoining land or the neighbourhood. He concluded that adjoining land was clear enough and that neighbourhood meant nearby. And then he said you can effectively read that language as a reference back to the easement with the language that I referred to earlier. So the other buildings and land of the vendor and his tenants adjoining or near to, and then the conveyed land. So having gone through that reasoning, he concludes as follows. I'm going to quote the judge again. He says, accordingly, in my judgment, the land for the benefit of which the covenant was imposed is sufficiently described in the deed itself. The formula used, that is, land of the vendor adjoining or near the land conveyed, is in substance the same as the formula successfully used in Rogers and Hosgood. So I'm going to stop sharing my screen. So as I said, it's worth noting at this point that the words he places great emphasis of in the which appear in the restrictions in the covenant were actually adjoining premises or the neighbourhood, not adjoining land. So it's not my bad transcription on the slides. The judge had actually misquoted the covenant at that point.
Well, thanks,
there you go, James. That's how he gets to it.
Well, I see the route now, although I can see that it's certainly arguable there are quite a few wrong turns in it. Martin, which of those did you identify in the arguments you ran on appeal?
Well, the key ground was our ground 2, and that is simply that we said the judge erred in construing the conveyance as identifying the land intended to be benefit as land of the vendor adjoining or near to the land conveyed. And what we said was that under ground 2 was the judge below had seized on those words in the easement reservation and treated those as synonymous with the words in clause 2, the covenant words of adjoining premises or neighbourhood, and that was simply impermissible. There's a very great difference between a neighbourhood and land of the vendor near to the land that's being conveyed. And what the judge had effectively done is he'd taken Rogers and Hosgood, where the words of the conveyance were, I think, adjoining or neighbouring land of the vendor, and effectively said, well, this is the same formula as was used in Rogers and Hosgood, which we've known for over 100 years, are sufficient words of identification in the conveyance. And of course, that really elides the question of whether or not a neighbourhood is the same as land near to the vendors, near to the land that is sold off belonging to the vendor. We question that. We also argue some other grounds. We argued, firstly, that there was no intention to attach the benefit to any lands, and that properly construed, the covenant was personal to the tenant for life, Captain Forrester, and or possibly for attached to the successive tenants for life. In other words, the son of Captain Forrester, who would have inherited thereafter, but was not a covenant attached to the land. Secondly, we argued that the judge was wrong to reject the requirement, as he did, that the land benefited had to be easily ascertainable. We relied there on Zetland and Driver and Crest Nicholson. And we said, therefore, that it followed that even if we were wrong on our first main ground, as it were, that the judge could and should, we said the judge could and should have concluded in any event that any land benefited was not easily ascertainable. And then our final ground was what we called the sort of severability ground. So we were saying that even if we lost on those other grounds, there were no words of severance. In other words, the covenant didn't say that the benefit was attached to each and every part of the land near to or adjoining, as the judge construed it. And we said that, particularly given that this was a pre-1925, pre-1926 case, that though it was fatal that the words and each and every part thereof were not used. So those were the main grounds of appeal that we relied on.
Well, thanks, Martin. And you've identified there your ground two, the question of whether or not the land intended to be benefited was adequately identified, is the key one. And as I read the judgment, that is how the court decided it. So Harriet, could you maybe explain how the court went about reaching that decision?
Yeah, sure. So Lord Justice Nugee gave the lead judgment on this ground. The court was sort of unanimous in its reasoning as well as its ultimate conclusion. And the way that Lord Justice Nugee got there is really through this route. He said he accepted that there was a clear requirement and that it was well established that land for the benefit of which the covenant is taken must be clearly identified in the conveyance creating the covenant. He said, and he accepted, that there's no particular formula to show that intention and to identify the land. He said, thirdly, that meeting that requirement can be done expressly by the express language or by necessary implication. He said, but it has to be remembered, and this is a sort of one of the takeaways we'll come to later, that this is ultimately a process of construction. And so it's not a process of inferring from surrounding circumstances alone. Now, why have I bothered to sort of give you those four headlines in terms of Lord Justice Nugee's reasoning? Well, hopefully it will become clear as I explain what he said about applying those principles to the instant case. So having outlined those principles governed his decision making, he said that the question was whether there can be found in the 1922 conveyance, either expressly or by necessary implication, a sufficient identification of lands intended to be benefited as to meet the requirement of conceptual certainty. And he said that he could accept the first instance, the judge below's proposition, that the language of the covenant showed in a general sense that it was taken for the benefit of adjoining premises or neighbourhood. But where he mainly differed from the reasoning of the court below is to say that it's not enough to see that the vendor owns adjoining property and that the covenant is, to use Lord Justice Nugee's words, inserted with a view to benefiting the vendor accordingly. He says that essentially he says something more is required, and it's that there has to be an intention that the covenant is taken for the protection of defined lands of the vendor, so that it goes with the land to successive owners, rather than being kept in the hands of the vendor for him to exploit. That's a reference to express assignments, another way of being able to pass the benefit of the covenant. So taking all of that and looking at the words of the covenant itself in this case, because he looks first at the covenant and then he looks at other aspects of the deed. He says, looking at the covenant, the words adjoining premises or neighbourhood that are referred to in the restrictions were not clear enough for the purposes of meeting the requirements. And there were three main reasons for that. The first, he says, the words are they more naturally define the content of the covenant, i.e. a nuisance or annoyance to that area of land constituting a breach. So it goes more to the question of whether there's been a breach. He said, secondly, that, and in any event, neighbourhood is inherently imprecise, and it's not clear enough to identify properties to which the benefit is intended to be annexed. And then thirdly, he said that the words in the covenant adjoining premises or neighbourhood are certainly not the same as adjoining or neighbouring land of the vendor, which was the language in the drainage covenant, although that language has also in other cases been found held to be clear enough. So that's why he wasn't satisfied that the covenant itself had contained clear enough language. He then looked beyond the covenant, and he essentially disagreed with the judge at first instance about the ability to refer back to the easement of drainage in clause 1, as I outlined earlier. And those of you who listened intently will recall that the easement said the other buildings and land of the vendor and his tenants adjoining or near to the conveyed land. But what Lord Justice Nudi had to say about that was again threefold. He said, firstly, the language of the restrictive covenant adjoining premises or the neighbourhood are effectively different words, and he made the observation that the draftsman, should be taken to have used different words for a reason. The second, that one would not expect landlord with the land which might be capable of enjoying a covenant against nuisance. He effectively was making the observation that you would expect the land capable of enjoying the anti-nuisance covenant to be much wider than the land easement. And so he concluded thirdly as follows. He said it's just asking too much of the words in clause 2 to make them do the work of identifying the scope of the covenant and also the lands of the vendor. So that's how we get to the conclusion that ground 2 was made out, and essentially the ratio of the decision is on ground 2, and appeal was allowed on that basis.
Well, thank you, Harriet. And I wonder what all this means for us going forward, what the implications are in future cases. Martin, what do you think?
Okay, well, let's be clear, as Harriet has said, like all of these cases that go to, particularly to higher courts, restricted covenant cases of this kind, the ratio is fairly tightly focused on the words of the 1922 conveyance. And much of the other observations, interesting though they are certainly obiter. We'll come on and talk about those interesting observations. So what it does is to reinforce the idea that nuisance and annoyance covenants can be drafted as widely as you like. They can cover all sorts of activities. And they can indicate that very wide tracts of land are protected by the covenant. But if the covenant fails to identify with precision the land benefited, then the covenant will fail to bind successors because the benefit will in practice not pass. I think that's the first sort of takeaway. I think the second point, it follows from that, that whilst it's common to identify land in respect of which no nuisance is to be caused by reference to a neighbourhood, very commonly worded covenant, this can't be relied on as defining benefited land. A neighbourhood is not the same as land near to the vendor's retained land. As Lord Justice Nugent said, neighbourhood is not a conveyancing expression. It does not refer to particular properties at all. So I think that gives a clear indication to drafters as to what they should and should not use the word neighbourhood for.
Martin, can I just interject there? Because we've had a few questions on the chat on that, including from Julian Steeden, from Brian Johnson. And Julian in particular has pointed out that neighbourhood is used in the context of town and village green cases to define the area from which the inhabitants have to come. And it strikes me that's a rather different context, because there you're not dealing with conveyancing, you're dealing with question of public rights. And there's no particular objection to a degree of imprecision in there, in that context. But in the conveyancing context, do you think it would be different?
Yes, I think it is. And the point, I think, was argued, if not below, then in the Court of Appeal, that the word neighbourhood is used, for example, in section 84.1, in one of the grounds for modification of covenants. As,
due to changes in the neighbourhood, the covenant has become obsolete.
Absolutely. And there, the courts, using that statutory framework, are perfectly able to identify where the neighbourhood is as a matter of practical fact. But it's very different in a conveyancing context. And here, of course, the idea is to give, the way this has developed judicially, is to give some sort of certainty to those advising a purchaser of land as to which land has the benefit of the covenant. If it's just the neighbourhood that has the benefit, then where does one start in advising a client as to which particular properties might benefit from the covenant? And I think it's a sort of practical consideration that has driven that distinction between near to and neighbourhood.
Well, and I suppose there's also a temporal element that you wouldn't get in the TVG cases, in that the covenant, of course, is to be construed as at the date of the conveyance, and working out what the neighbourhood was at that date may be much more problematic than working out what the neighbourhood is today.
Yeah, exactly. And that's the same, of course, in the Section 84(1) context, that the neighbourhood is the neighbourhood as at today, as at the date that the application is made for modification, not at some ancient time in the past. So I think that's an important takeaway. I think that probably the next point is that, in spite of Section 78, which of course implies words into covenants, I suppose this case really reiterates that the land benefited must be clearly defined. And if it's intended, then the formula and each and every part should also be used. I mean, the court didn't answer that question, but it must, as a matter of practice, be the sensible thing to do. I think the other point, of course, perhaps more importantly, is that there is no substitute for using the time-honoured formulae that the Court of Appeal referred to for showing the intention to attach the benefit to particular land. That is either expressing the fact that the covenant is with X as owner of defined land, or alternatively that the covenant is for the benefit of the Bath estate or some other defined area of land. So, I mean, to state the obvious, it will be insufficient, I think we can say pretty generally, to elide land adjoining or in the neighbourhood with, for example, land of the vendor near or adjoining the land sold. That was the formula in Rogers and Hosgood, which is acceptable. So it reinforces, I suppose, the requirement to identify land, quotes, this is from Lord Justice Nugi, to the level of conceptual certainty, whatever that means. I think it underlines, though, that words such as adjoining land of the vendor may be sufficient, but it's better to define land more clearly. I think the second point is that, albeit obiter, it clarifies a question of relating to implied annexation. In order to rely on it, a potential beneficiary of the covenant can't rely simply on an inferred intention looking at surrounding circumstances alone. Lord Justice Nugi made clear, and I think the other two judges agreed with him, that you can construe the covenant in the light of surrounding circumstances, and if, and really only if, as a matter of necessary implication, it can be construed as benefiting particular land, then that's good enough for implied annexation. But I mean, inferentially at least, nothing less will do. So what is needed for implied annexation is an intention or express, if we're relying on express annexation, or implied as a matter of necessary implication that the covenant is taken for particular land. So I think probably those are the main sort of takeaways, and those who are listening and involved in drafting of covenants will no doubt hopefully see that there are some important points there, if only by way of reiteration of what we already know.
We've had a question from Roy Perrott asking whether the outcome would have been the same if this was a post-1925 Act covenant, and so raising the question of whether or not the 1925 Act makes a difference to this reasoning. And again, let me see if I've understood what you guys have been saying correctly. Given there are two requirements for annexation, the question of the intention to annex and the question of the land to be annexed, would it be right to say that the 1925 Act, section 78, goes to the first of those questions, whereas this decision is really dealing with the second of those questions, and hence what it says will be of interest to us with post-1925 covenants just as much as pre-1925 covenants?
That's absolutely right, James. I mean, section 78 says, of course, that a covenant attaches automatically to land of the covenantee intended to be benefited. But of course, that doesn't get you over the hurdle of identifying the relevant intended benefited land. So it is of relevance both to pre and post 1925 cases.
Well, thank you for that, Martin. Now, we've identified, we've talked about the decision on ground 2, which resolved the appeal in your circumstances. And Martin, you've talked about what was said about implied annexation as well. Was there anything said on any of the other grounds that should interest us?
Well, yes. I mean, in fact, possibly the more interesting points were dealt with obiter. And in particular, as I indicated, we argued that the requirement of easy ascertainability was a separate requirement, an additional requirement of annexation, i.e. not only that the land needs to be identified expressly or by necessary implication from the conveyance, but also that it had to be easily ascertainable. And that's supported by leading textbooks, Scammell and Preston and Newson, but it also has the support of two Court of Appeal cases, Zetland and Driver and Crest-Nicholson. Now, on this question of whether a separate test was appropriate or whether that is the law, the court didn't have to decide the point because they decided the case purely effectively on ground 2. Nevertheless, they made some important observations and there was disagreement. So Lord Justice Nugee agreed with the judge below that easy ascertainability was not a separate test, but meant no more than that it was sufficient for the conveyance to describe the land intended to be benefited in terms which enable it to be identified from other evidence. And what the judge below had said was that that test is the same as a test of easy ascertainability. There's no distinction between the two. What Lord Justice Nugee did say, though, was that the judge below had gone too far in saying it was not necessary for the land to be easily ascertainable. But he was right to say that the two tests, the test that I've just identified and easy ascertainability, did not differ significantly in practice. Now, that was the subject of comment by Lord Justice Newey and Lord Justice King, who really disagreed with Lord Justice Nugee on that point, or at least they went as far as saying that they were much more doubtful as to whether the judge below was right to elide the two tests. And they relied, I think, convincingly on the fact that in one of the leading cases, which really seems to set out a separate test of easy ascertainability, the Crest-Nicholson and McAllister case from 2003, what Lord Justice Chadwick did there was to really provide a policy justification for the easy ascertainability test. In other words, he said, well, there's good reason for the question to be one not only of sufficient identification from the conveyance, but also easy ascertainability, which is that any purchaser, any purchaser's solicitor advising a purchaser needs to be able to give relatively clear advice as to who has the benefit of the covenant. And that's a good reason for making the easy ascertainability test, in effect, we would say a separate requirement.
Can I interject there again, Martin, with a question on that? And it's a question we've had, in fact, in the chat from Julian Steed. That policy justification suggests the test to be applied as at today's date. But I'm not sure that's actually what the court says, is it? What do they say about the timing of easily ascertainable?
No, I mean, that's absolutely right. We tried to argue that it had to be easily ascertainable, both at the date that the covenant was entered into and at any time that enforcement was being sought. And the court, I think rightly, I have to say, dismissed our argument that it had to be easily ascertainable as at today's date. Clearly the requirement, if it exists, of easy ascertainability is one that only applies as at the date that the conveyance it was entered into.
Well, I mean, just picking up on that, what the court seems to envisage is that you're looking at the language of the conveyance, you're asking yourself whether that language indicates that there's an area of land which is intended to be benefited. The mere fact that you might, if that is done in a way that enables you either to sort of immediately point to a map and say that must be the area that's being referred to, then you've got conceptual certainty, use Nugie's language, or you straight off the bat meet the easily ascertainable requirement. But he also indicates by giving us a sort of an example that if there is that some language which indicates an intention to benefit and refers to an area of land that may be, then the mere fact you might need to go and try and find some extrinsic evidence in order to work out what that area of land may have been at the date of the conveyance itself, that likewise should mean that you don't fall foul of the easily ascertainable requirement. So I mean, the court's guidance doesn't really go much further than that. I think that's kind of what we get out of, well, I mean, I don't know, Martin, whether you've got, or James, whether you've noticed anything else, but I think that's as far as this case goes in terms of giving us a clue as to what easily ascertainable might be and, when you might reach its limit.
I mean, you could have a circumstance where it was easily ascertainable as at the date the covenant was entered into, because, for example, there was a plan there showing the delineation of the Hutchings estate or whatever the benefited land was meant to be. And then 100 years later, that plan could have been lost. And so you couldn't prove the extent of the land that it entered into. And in that situation, would I be right to say the analysis would be, well, there was annexation. It's just you can't prove today, as a matter of forensic reality, what the land annexed is.
Exactly, yeah. And so it then becomes, a sort of Nugie put it, there's an evidential hurdle as at the date that you're trying to enforce. And if evidentially you can't establish as the enforcer that you own some of the land that could have been easily ascertained back at the date of the conveyance, then you may fail in your enforcement for that reason. But that doesn't mean that there wasn't that the requirements of annexation were not met as at the date of the conveyance exactly.
So annexation is a yes or no answer, and the question of whether you can prove you own land that benefits is a separate one.
Yeah. Absolutely. And of course, I mean, I suppose I would say unfortunately, but perhaps unusually in this case, although the conveyance was 100 years old by the time the case was heard in the Court of Appeal, there was an unusually good body of evidence showing that the 7 1/8 respondents' land had formed part of the retained land of Captain Forrester when the conveyance was made. So it wasn't a case that needed to get into that question of what easy ascertainability actually means in the circumstances. And as to which, I mean, the only real guidance, there isn't really any guidance that comes from the cases on what those words mean, although they've been clearly used in several cases, including, as I've mentioned, 2 Court of Appeal cases. I mean, the suggestion might be inferred, as it were, from Lord Justice Chadwick's judgment in Crest Nicholson, that what you need is an equitable minimum quality of evidence, so that you can say with sufficient certainty to a purchaser that that land is benefited land. What that actually means in practice is another matter, but I think you come back to the policy justification to try and look at and understand what easy ascertainability means, but it's not a straightforward question.
And one of the questions we've had from Brian Johnson on the chat maybe highlights this issue, because he's wondered whether you could use the postcode to identify the land. So you could say the land to be benefited is that within the same postcode as the property conveyed or transferred. And presumably on the face of things, that would satisfy the conceptual certainty, but it could give rise to forensic difficulty in future as postcodes change over time. Yeah,
absolutely. I mean, perfectly. Yeah, I mean, there is then that raises the question latterly of evidence at the time the covenant comes to be enforced. But in principle, there would be nothing wrong with identifying it by reference to a postcode, all land of the vendor within postcode XYZ.
Yeah.
Okay, well, I see time is moving on relatively rapidly. Just really to mention the two other grounds which were argued, but not really answered. The first, as I mentioned, we relied on the fact, or we argued as one of our grounds of appeal, that the words successors in title were insufficient to show an intention to annex the benefit of the covenant to particular land. And that relied on the fact that Captain Forrester had a life interest under the settlement. And we argued that successors in title was a reference to those succeeding to his life interest. Or alternatively, we said it was to those who succeeded subsequently to the strict settlement, having their own life interests, such as his son, who presumably would have inherited after his death. Now, the Court of Appeal didn't need to decide this, and they said they were doubtful of our, what they called, narrow interpretations of the word successors in title. I suppose the practical point that comes out of that is that certainly when you're dealing with settled land and drafting in relation to that, is to make clear when using that common phrase, successors in title, whether you're referring to successors in title to particular land or to or whether the concept is being used in some other way. But the Court of Appeal gave us no clear guidance on that point. And then finally, the Court of Appeal also didn't really need to grapple with a further ground of appeal, which we put forward, as I've mentioned, that in any event, the benefit wasn't attached to each and every part of the benefited land, so that the 7th and 8th respondents, who obviously only owned a little part of what Captain Forrester had retained, were not entitled to enforce. I mean, again, that was an argument that relied pretty heavily on pre-1925 authority, and it's an interesting and complex one, which understandably the Court of Appeal didn't feel they needed to grapple with.
Well, thank you, Martin. Plenty then to wait for in future cases. I'm afraid that's out of time. I've tried to pick up as many of the questions as possible as we've gone along, but apologies for those I haven't had a chance to pick out as we've gone along. Thank you very much, everyone, for attending today's webinar. We value your feedback, and when you close your browser, or so once the session is over, a feedback form will pop up in your browser. And if you've got a couple of minutes to fill that in and let us know what we could do better in future, or even what you like today, that would be great. We'd really appreciate that, so we can make these sessions better in future. The recording of this webinar will be available on the Chamber's YouTube channel, so you can catch up on anything you missed or watch again if there were bits you'd like to go over again. To find that, just type Wilberforce Chambers in the YouTube search bar and it should hopefully come up. We'll also send you the slides after the session is finished, so you can have those if you want to refer to them in future. So all that's left for me to do is to say thank you, Martin and Harriet, and thank you everyone for attending.
Thank you. Thank you all.
Thanks very much, James, for chairing, and thanks everybody. Bye.